Allow me to distract you for a few minutes just to go into some of the background facts to a recent case in the Technology and Construction Court in the UK, celebrated case of Lilly Construction, Walter Lilly Construction versus Mackey and another. The project was one set up by Mr. Mackey, the defendant in the case. He and two friends bought a property, a site in London, and the purchase price of which was 13.2 million. And they agreed with Walter Mackey or with Walter Lilly that Lilly Construction would construct 3 houses on the site for about 15 million sterling. The project was an ambitious one. It included every luxury you can think of, including underground swimming pool, cinemas, etc. Mr. Mackey had 8 internal consultants of his own dealing with different aspects of the package, including his architect, structural engineer, and so on. The judge described the project as a disaster waiting to happen, and that was basically because the design had not been completed by any stretch of the imagination and left an awful lot to be desired at the opening stage, and the 8 consultants weren't working with one another and weren't dovetailed in the effort. Now, Mr. Mackey himself was an interesting and colourful person, still is, I imagine. He was very wealthy. The judge described him as somebody who was used to getting his own way. He was a forceful man. And he wrote very forceful emails. Of the 32,000 documents that were put before the court, several of the emails were read out by the judge in his judgment of 150 pages. Because of the aggressive manner of Mr. Mackey's way of dealing with people, the judgment is peppered with crossword clues, such as 7 letters ending with G and 6 letters ending with OR. Mr. Mackey got off to a good start by saying in an email to one of his partners that his wife should keep her nose out of it and that she could do with a good thrashing. The project commenced. Problems immediately came to light. There were gross delays. Costs started running up. Mr. Mackey, true to character, failed to engage with the design team in relation to the problem and started to play the blame game. All of this was found by the judge. About a year, the project was meant to be 18 months, and it took 4 years. The cost doubled at least. The litigation cost, the judge found, was at least 10 million on the evidence of Mr. Mackey himself. One disaster led to another, and eventually Mr. Mackey brought in Knowles, the well-known claims consultants, to advise him and basically to put the architect, the design team, and the contractor all under pressure. The judge found that Knowles' approach to the architect, in fact, constituted employer interference. Mr. Mackey ended up paying $800,000 to Knowles, and the judge found that there was no value in that $800,000. Mr. Mackey ended up suing 4 of his 8 consultants. He, in turn, was sued by his own lawyers, by Knowles for their fees, and by the replacement architect that he had put in because he was afraid the existing architect would give an extension of time. The whole episode obviously was a disaster for Mr. Mackey. He lost the case big time, and that in turn cost him a fortune, mainly in fees rather than the compensation payable to Walter Lilly. So the relevance of that, had Mr. Mackey involved himself in dialogue with the design team at the outset, a huge amount of the later disasters could have been avoided. And there's obviously a parallel to that situation and what we are talking about here today. In 2007, the state picked up the ball, ran away with it, produced its own form of contract in a spirit of transferring risk to the contractor as much as humanly possible. Some of the provisions in the contract are not just unfair, they are actually immoral. Bernard referred to one of them, being the requirement for all of the arbitrators' awards to go to the Department of Finance, and Niamh O'Higgins is going to deal with another. Certainly we need to review that contract, but we need to be talking far beyond that contract. We need to be talking about adjudication. We have this construction contracts bill that people talk about as if it's the panacea to everything. We don't know what's going to be in that bill. Well, sorry, we do know what's going to be in the bill. We don't know what's going to be in the Act. Is there going to be a need for a bond? If there is going to be a need for a bond, and it's for the full amount of the conciliator's recommendation, adjudication will be useless. It won't work. There's meant to be a code of procedure. It will not be implemented. It may be enacted, but the Act will not be implemented until the code of procedure is brought in. That has never been discussed. My emphasis is on discussion. We need to be talking about these matters. The Construction Act, as it will be, Construction Contracts Act, should not come as a surprise. If it has been properly discussed, it will be a good piece of legislation and everybody will have an input. Thank you.